Please be seated. Good morning. We are here today for oral argument in our case number CV230171, Garcia versus Dealers Auto. Each side has 20 minutes for your argument. I would ask the appellant, if you want to reserve time for rebuttal, do so. Just keep the track of the time yourself. Our proceedings are being audio and video recorded this morning, so if you could introduce yourself and your client at the outset, that would be appreciated. We've read the briefs, discussed the case this morning at conference, and are familiar with the issues raised. So if you can also keep that in mind, that would be terrific. And with that, you may proceed, counsel.
Good morning, Your Honors. I'm Veronica Fabian, and this is my co-counsel, Young Choi. We are counsel for appellant consumers. When my clients bought these vehicles at Arizona Road Trip was a licensed used car dealership. Everything happened just the way it always happens when you buy a vehicle at a car dealership from their perspective. They test drove vehicles, they picked a vehicle, they signed all the paperwork they were supposed to sign, they paid for the vehicle. Arizona Road Trip issued them temporary registration plates and temporary registration as it was authorized to do under Arizona law. They expected to receive title, permanent registration, and plates in the mail because that's what Arizona Road Trip was supposed to do under Arizona law. They had no idea that Arizona Road Trip hadn't paid for these vehicles. Now, why was Arizona Road Trip able to sell these vehicles to my clients without paying for them first? The reason is because the auction where Arizona Road Trip bought these vehicles, Dealers Auto Auction, let them take the vehicles without paying for them first. The auction did this even though it knew that Arizona Road Trip was in serious financial trouble as early as November of 2020. At that point, they were talking about repossessing vehicles. They didn't. Instead, they let them keep taking vehicles without paying for them. The auction made the decision and took the risk that buyers in the ordinary course would buy these vehicles, like my clients. So what happened next? Arizona Road Trip goes out of business and doesn't pay for the vehicles. Dealers Auto Auction gets the titles to these vehicles put in its name. Now, in order to do that, it has to submit fraudulent documentation to the Motor Vehicle Division. That's because it wasn't the owner of these vehicles. It was not the buyer, it was not the seller, it was the facilitator of a sale. It was not the owner. So it had to submit fraudulent documentation. It then took these vehicles.
Sorry to interrupt. All of your clients paid cash for the vehicles?
All of my clients paid in full in cash.
And when you pay cash for a vehicle, even at a dealership, don't you expect to leave with title? Shouldn't you expect to leave with title?
No, I think that when you pay for a vehicle, it's a regular course that dealers register and title your vehicle for you. Part of what they paid for in the buyer's order, you'll see, are plates, which to them considered title and registration. And so dealers almost always, it's a standard practice that dealers in Arizona title and register the vehicle, and then it comes in the mail later on. That's standard course. So the auction took the vehicles, even though they weren't the owners, even though they weren't the secured parties, and resold them. The consumers, who were all blue-collar workers who had worked hard to save money to buy these vehicles, were left sometimes for months without any kind of transportation. It was the auction that took the risk that buyers in the ordinary course would buy these vehicles. That's why under the entrustment provision, the consumers, my clients, were the owners after they bought these vehicles from Arizona Road Trip.
Were all the vehicles repossessed? My understanding is
yes, you're right. There's two people that the auction just took title in their name and refuses to release title. There are two, Federico and Brandon. Yes, you're correct. Now, I'd like to talk about the entrustment provision first. Under ARS 472403, any entrusting of goods to a merchant who deals in that kind of goods gives that merchant the right to transfer the rights of the owner, the entrustor, to a buyer in the ordinary course of business. A buyer in the ordinary course of business is defined as a person that buys goods in good faith without knowledge that the sale violates the rights of another person in the goods and in the ordinary course from a person in the business of selling goods of that kind. That's exactly what happened here. The sellers of these vehicles were dealers and finance companies who sold through the auction and used the auction as an agent. They entrusted these vehicles to Arizona Road Trip through their agent, the auction. Therefore, Arizona Road Trip had the rights of these sellers to transfer to buyers in the ordinary course of business, which were my clients. This not only is the fair result, but it also promotes the free flow of commerce because a consumer shouldn't have to go look at title every time they look at buy a vehicle.
Can you explain the mechanics of looking for title?
Sure. Under the Driver Privacy Protection Act, you can't just go to MVD and look at a title history. You have to have a permissible purpose. And buying a car is not a permissible purpose. So the only way to actually look at the title that MVD has on record is to take the owner whose name and personal information is on that title with you. And that is, of course, what you do if you buy a vehicle from a private party. But if every car dealer had to go with the consumer, every time someone went to buy a car from a car dealer, if the consumer and the car dealer had to go to MVD together, that would be completely slow commerce. In fact, bring the sale of vehicles almost to a halt. And the other thing is that the Arizona titles don't actually have all the information on them. On the back of a title, you can transfer it repeatedly. So even if you went and looked at title and it said Arizona Road Trip, they could have sold it to another dealer, another person on the back, and you wouldn't know. So the title history that they have is not complete. And finally, Arizona doesn't keep track of out-of-state titles until it gets registered and titled in Arizona. And so, for example, Diana and Federico both had Texas titles for their vehicles. So that means the lower court's decision that they should have looked at the title history means that they would have had to look at the title history for all 50 states, which is just completely unworkable. Judge Hopkins' decision also, basically what he held is that they did not act in good faith because they didn't look at the title history. His decision ignores the definition of good faith under the Uniform Commercial Code, which is honesty in fact in the conduct or transaction concerned. And this court has held that that's a subjective test, that's whether the buyer honestly believed nothing was wrong. And here there's no dispute that the consumers honestly believed nothing was wrong. Judge Hopkins followed a New York case, 30-year-old New York case, Kaminsky versus Carmen, which has been superseded by statute. In that case, there was a consumer who consigned their vehicle to a car dealership. The car dealership then sold it to a buyer, but didn't pay the consumer consignor. And what the New York court said is that the buyer was not in good faith because they should have looked at the title history, especially in light of the fact that there were private plates on the vehicles. Now, the Kaminsky court also ignored the definition of good faith in their analysis. They didn't even talk about it. But it's also a distinguishable case because, one, there were private plates on that vehicle. There were no private plates on the vehicle in this case. Two, the issue was between consignor to consumers. The equities were different. Right here, the auction enabled this to happen, and there were the people with the expertise to prevent this kind of thing. But nonetheless, they let Arizona Road Trip take these vehicles.
Was it a UCC case?
It was. There were two different issues, but they did say that they did not act in good faith.
So what statutes superseded the case?
They amended the consignment. They amended the Article 9 provisions regarding consignment, and that superseded the case. As I said, Kaminsky, 30-year-old case, nobody but Judge Hopkins has followed it in 30 years. This court shouldn't follow it either. This case, also under the Arizona Supreme Court in Price versus Universal CIT, the consumers were the owners. Now, that case was decided shortly, like about a year before the Uniform Commercial Code and the entrustment provision were adopted in Arizona, but it's based on the same principles. In that case, very similar. There was a financier that loaned a consumer, or loaned the car dealership money to buy cars and then held onto title as a security. And then the car dealer sold the vehicles to good faith purchasers and then absconded with the money. This happens apparently a fair amount. And then what happened, the issue was between the finance planner and the good faith purchaser. And the Arizona Supreme Court held that the consumer obtained good and clear title to these vehicles, even though they had not looked at the title history, even though they had not even asked to see the title, even though at that time the dealer was required to have title at the time of sale, just like there's a statute right now. It was different numbering, but same requirement. And even though the constructive notice provision was already in effect, just the predecessor in interest. So I'd like to talk about the constructive notice provision. The auction has argued throughout this litigation that the consumers were not buyers in the ordinary course of business because they had constructive notice the Arizona Road Trip was not the owner of these vehicles because its name was not on the titles. Now first, the Uniform Commercial Code requires actual knowledge. Constructive knowledge is not enough. But even if constructive knowledge was enough, this statute doesn't give constructive knowledge of all existing interests in the vehicle like they claim. It gives constructive knowledge of liens and encumbrances. In this
Can I
case...
ask about actual knowledge? My understanding, usually with respect to actual knowledge, actual means you knew it or you should have known it. Does the UCC use that nomenclature, or is the UCC, you either know it or you don't, and we don't even look at should have?
It's knew it or should not, or no, I'm sorry, actual knowledge. It means actual knowledge. That's how it's defined under the UCC. And there's a Court of Appeals case, Snap-on Tools, that says actual knowledge means actual knowledge, not should have known.
So how does, like, willful ignorance play in under the UCC, if at all?
I don't think it really plays in under the UCC really at all, except that the requirement that the goods be bought in the ordinary course of business protects against that. Like if you're buying a car from, somebody on the, somebody from a car dealer at Bash's or whatever, like someplace that not in the ordinary course of business. A lot of times they talk about bad faith or good faith and in context of, they're involved and they know what's going on. They actually know what's going on. I guess that's a little different from willful ignorance, but I think that's why there's the ordinary course of business. That protects against those things, as long as it's happening in the ordinary course of business. I mean, of course, if they had actual knowledge, that would be a different situation. So...
Can you talk about what relief you're seeking and whether it's what that relief, whether it is possible with the two owners who are not, I guess, their cars were taken and, yeah, those two.
Okay, yeah. Well, we have asserted conversion claim, and I believe we are seeking, well, in this court, we're seeking reversal of the summary judgment. And we are also, in conversion, we're asking for the value of the vehicles, loss of use, loss of improvements, if that's what you're asking.
No,
I'm sorry.
Procedurally, you're asking reversal of summary judgment and entry of summary judgment?
Yes, we're asking for reversal of summary judgment and entry of summary judgment in the consumer's favor.
And how do the differences between the two and how many others are there?
There were 11. So
11. So the 2 and the 9 impact our ability to enter a summary judgment for all 11.
I don't think it makes any difference. There's a conversion claim based on the taking and reselling of the vehicles, but there's also a conversion claim based on the auction putting title in its name when it was not the owner and then refusing to release title. So my clients, the two who didn't get their vehicles repossessed, can't drive the vehicles. So it's in essence like they took them.
I'm not sure we can grant full summary judgment on conversion, though, because at the very least there's issues with respect to damages, I would
Absolutely,
think.
absolutely.
So which elements of the conversion claim are you asking us to enter summary judgment in favor? All the others other than damages?
The liability, that they can, because the consumers were the owners here of these vehicles, they converted these vehicles by repossessing and reselling them or by holding onto the title when they shouldn't have held onto the title. And that leads me to my final point that I wanted to talk a little bit about the title. The auction has argued that the owner on the title is that they were the owners of these vehicles because they were on the titles at the time of the repossession. But under Arizona law, the owner on the title is not dispositive of who's the legal owner. And that's particularly appropriate in this case when you see the kind of documents that they were submitting in order to get their name on the title, they were submitting fraudulent documents. They had to because they were not the owners. They were not the buyers or the sellers. They were not the owners. So I wanted to show you one example. And this is the title for one of the consumers, Abraham Ramos. Do you mind if I come around?
Just a moment. Has opposing counsel seen this?
Yes, I'm familiar with that document.
Did you receive notice that it was going to be used in the argument?
Is it, and it's part of the record, I
It's part of the
suspect?
record, yes.
All right. Go ahead.
So as I said, this is the title for Abraham Ramos. So this vehicle, Arizona Road Trip bought this vehicle from Avondale Toyota, who's right on the title, on December 30th, 2020. It then sold it to Abraham on January 13th, 2021. Avondale Toyota then got titles issued in its name after that sale, which is February 1st, 2021. And you flip it over, and on the back side, signed title over to Arizona Road Trip as of December 30th, 2020, before my client bought it. So what happened is that this title was sent to Dealers Auto Auction. And when Dealers Auto Auction decided that Arizona Road Trip wasn't going to pay, it had a problem because there was this title, and a certified or a legal document that had Arizona Road Trip as the buyer. So what they did is they submitted this document, the statement of error, and on that they list that Arizona Road Trip's name was entered in error, and that Dealers Auto Auction itself should have been entered. But that's not true. They were not the owners. They did not buy the vehicle. I am going to reserve the rest of my time for rebuttal. Thank you.
Thank you, counsel.
Good morning, Your Honors. McKay Worthington of Willenchick and Bartness on behalf of Pelley Dealers Auto Auction in the Southwest. This appeal is about the issue of knowledge. The question for the court is, what did the plaintiffs know at the time that they paid Arizona Road Trip for the vehicles that are at issue here? And when we determine what the plaintiffs knew, we are on the way to the conclusion of the case. And that's because there's a single claim in this lawsuit, which is conversion. There's no dispute between the parties that in order to succeed on their conversion claim, the plaintiffs have to prove that they had the immediate right to possess the vehicles at the time they were repossessed. If they didn't have the immediate right to possess the vehicles at that time, then no conversion occurred. So, and the only argument that the plaintiffs make that they did have the immediate right to possess those vehicles is that they were buyers in the ordinary course of business under the UCC. But whether a person's a buyer in the ordinary course of business under the UCC depends entirely on what the person knew at the time of the purchase. The definition of a buyer in the ordinary course of business under the Arizona UCC is, quote, a person that buys goods in good faith without knowledge that the sale violates rights of another in the goods.
And counsel, in your pleadings, you say that the plaintiffs purchased the vehicles while knowing that Arizona Road Trip did not own them. How can you walk us through how a buyer gains that information?
Sure. The way that a buyer, it's knowledge that the buyer has as a matter of law in Arizona. So
That satisfies the actual knowledge? It's actual knowledge under the UCC, right?
no, under the UCC requires actual knowledge. The constructive notice statute that we've referred to that's in the transportation code imposes constructive knowledge whether the person has actual knowledge or not. Purposely, they said actual knowledge does not matter in the context of knowledge about interest in used vehicles.
Let's start with actual knowledge. If we disagree with your position and we think it's actual knowledge that applies, do you agree that the plaintiffs did not have actual knowledge of these issues?
We haven't completed discovery of that issue, so I'm not sure whether any of them had actual knowledge of that issue or not. But our position is there's a statute.
At summary judgment, did you move for permission to conduct more discovery by motion?
We didn't at that time.
Okay.
Yeah, in fact, you don't know means you were not entitled to summary judgment. I understand it might mean that the plaintiffs also are not entitled to summary judgment, but it means you weren't either.
I disagree, Your Honor, because I don't believe the actual knowledge standard of UCC can apply to this case.
No, I understand that, but that's a different issue. I'm saying assume it does apply. If it does apply, you're saying at the very least you don't know whether there was actual knowledge or not. And if you don't know, or your client doesn't know, then they were not entitled to summary judgment.
If the actual knowledge standards applies, then we don't have proof that these plaintiffs had actual knowledge that the dealership didn't own the vehicles.
Okay, can you continue walking me through how they would have had constructive
Sure.
notice?
So ARS 282133B, which we've been calling the constructive notice statute, says subsequent purchasers, like all these plaintiffs, have constructive notice of the interest listed on the title to the vehicle. I'll quote it. It says, the filing and issuance of a new certificate of title, as provided in this article, is constructive notice to subsequent purchasers of all liens and encumbrances against the vehicle described in the certificate of title.
Did the plaintiffs purchase liens or encumbrances?
Did the plaintiffs purchase? They were purchasing vehicles that were not being sold by an entity that did not own the vehicles.
Right, but they weren't purchasing liens and encumbrances, which is how I read 282133B to apply. It's imparting knowledge to the purchasers of liens and encumbrances. These folks are purchasing a vehicle. They're not purchasing credit.
Okay. I'd like to address that argument because it was not raised until the reply brief. So you don't have our written response to that argument.
But before we go down that road, I'm still interested in hearing how an ordinary buyer who walks onto a used car lot is able to determine who is on title for a particular vehicle.
They are by statute deemed to have constructive
Right, I understand that. My question is, if I go into a lot today, how do I go about ascertaining the title holder for a particular vehicle? I mean, obviously, your position is that I cannot assume that the name on the sign that for the lot that I'm walking on, I cannot assume that they own it. So how can I, as a consumer, determine who owns it?
Well, luckily for consumers, the Arizona Department of Transportation has provided information specifically on what they're supposed to do, and we included that. If you look at what the ADOT tells purchasers of used vehicles to do, it informs them that they must check this title to be sure there aren't any other claims against that vehicle. And they put it in bold on their website.
In practice, how do they do that, I think is Judge Cruz's question.
There's multiple ways.
I need to go find the owners, and I need to bring the owners into to ADOT's office and get permission from them to look at the title, or?
One method is to ask for permission from the dealership. So they could have said, we want you to authorize us to go check the title and see if you're owners or not. And then if Arizona Road Trip had authorized them to do so, they could have gone to ADOT and found out whether the dealership owned the vehicles or not. Or they could have gone down and sought that information directly without doing that. And there's some dispute. We've been doing some testing of what ADOT actually does in practice when people go in the office and ask for this information, and it's very different than what's being presented by the plaintiffs in this court. ADOT will give you information about vehicles if you go in and ask about them.
But don't you have to fall into one of the several categories of need for that information? I mean, I can't just show up with a plate number and ask information about a vehicle, can I?
Yeah, well, what we found is in some cases the clerk will give you the information, in some cases
Are they permitted by statute to do that?
Whether the ADOT is permitted to do that, they have to make their own determination on whether it's permissible use of that information. But as I mentioned, the first thing that you can
Okay,
do,
so that, now we're getting somewhere. So is being a potential buyer, does that put you within the category of permissible use? Does that fulfill the category of permissible use?
I haven't tried to analyze that. There's like 14 different potential exceptions. I haven't tried to determine if there's one of those that would fit.
Well, then how do we know that these buyers could have determined the ownership?
Well, I don't know that on that process, but there's another process, which is the first one I mentioned, which is they could have gone to the dealership and said, we want to make sure you own these vehicles. We authorize us to give us that information. They'd give them written authorization. They could go and check with ADOT because they had the written authorization. Now, if they'd said, we want to check and see whether you actually own these vehicles, and the dealership said, no, we're not going to authorize you to get that information, that's a pretty big red flag to a purchaser, right? The seller won't let you figure out if they own the vehicles or not. So those were at least two of the methods by which the plaintiffs could have obtained actual knowledge, but actual knowledge is not required. There's a specific statute that governs what knowledge subsequent purchasers have about interest in vehicles.
Outside the UCC.
Yeah.
Inside the UCC, it says actual knowledge is actual knowledge.
Correct.
So you're looking for us to sort of reach outside to pick a definition and then bring it back to the UCC.
And that's because the Arizona legislature said that the exclusive method, there's one method that's exclusive for determining what interests, for what knowledge a buyer has about a vehicle. You can't go to actual knowledge under the UCC. You can't go to any other source of knowledge. There's one source of knowledge under the statute that is exclusive, quote, exclusive. And that is what appears on the title.
Well, again,
there's very good
the
reasons for
question
that.
of knowledge about what, and the way I read the statute that you're relying upon, it's about secured creditors and providing notices of liens and encumbrances. And if you're a subsequent purchaser of secured credit, then you have constructive knowledge based on what's in the statute. But what is the textual hook for us saying this also applies to purchasers of vehicles and somehow modifies Article 2 of the UCC, which is different than Article 9?
Well, there's two arguments I need to make to respond to that. The first is that that interpretation of the statute is an absurd interpretation because what the plaintiffs are saying that, and now dealers could have listed itself as the owner or as the lien holder on those titles. It owned the vehicles, and another party, the dealership, owed them, but they were the debtor that had to pay for them, so they had a secured interest in those vehicles. They could have listed themselves as lien holders, in which case Ms. Fabian would admit, well, we weren't buyers in the ordinary course of business, and we don't have a conversion claim. But since the dealers listed themselves as owner, that difference, they're saying, means that they weren't purchasers, that they were purchasers in the ordinary course of business. And I just think that's absurd. And I'll go back to waiver issue in a second, but.
What's your textual hook in 21-2133 that gets us to say this statute applies outside of liens and encumbrances and to the underlying purchasers of vehicles?
And it's because under State versus XRL Florney versus Magnum, which is an Arizona Supreme Court case that I cited in the summary judgment brief, and when the issue did come up, it didn't come up in the appeal until the reply brief. But I did address it at the trial court level. I wasn't able to address it here because it didn't come up until the reply brief. But the court said, in interpreting statute, a sensible construction should be given which will accomplish the legislative intent and purpose, which will avoid an absurd conclusion.
I understand the absurdity canon, but what language in this statute can we rely upon to say it applies to purchasers and modifies Article 2 of the UCC?
Well, it says it applies to subsequent purchasers.
Where?
Right in the statute.
Liens and encumbrances. So what do I do? What do I do with that language?
Well,
I can't. There's another canon that says I can't render language to be superfluous.
And I'm not asking you to find that language to be superfluous.
And I can't write things into statutes that aren't there already. And so when it says liens and encumbrances, I don't think I can, as a judge, say and purchasers of vehicles.
Okay. Well, at this point, Your Honor, I'm going to ask you to not consider that argument because it was waived. We didn't have the chance to respond to it. I have a long written response to that argument if it had been raised before the reply brief. What happened at the trial court level, that argument was raised on summary judgment in a one-sentence footnote.
So that's how this works. They make arguments in their opening brief. They say the UCC applies. You come back in your answering brief and you say, no, it doesn't. This other statute applies. And then in their reply brief, they say, no, that response doesn't work because X.
Well, that's
why we have reply briefs, is to respond to things that you might argue for the first time in your answering brief.
Well, this was briefed and argued at the trial court level. It's not an argument they weren't familiar with.
So you can speak to it now. You have 8 minutes.
We're here.
Okay. Well, I've been speaking to it, and my argument is that you have to look at the purpose of the statute, which is to protect interest holders in vehicles. If you own a vehicle or you have a lien on a vehicle, and somebody can sell your vehicle in a fraudulent transaction, and you're just out of luck, unless if you were the owner, but you're not out of luck
How
if
does it
you're
protect
legal.
purchasers of vehicles to require them to go down to the DMV and physically look at title before they're protected in vehicles that they're purchasing? That seems like a sea change in how people purchase vehicles in Arizona.
Well, the point of that statute is not to protect the purchaser. It's to protect people who have interest in the vehicles, and they have legal interests too. They have legal rights that can't just be swiped away because other people have different interests. That statute
Right, I
exists.
think your client has very good claims against Arizona Road Trip. I'm trying to understand how we get to repossessing the plaintiff's vehicles.
Well, our client paid for each and every one of those vehicles. They paid the actual
And
owners.
so did the
of
plaintiffs, right?
No, they didn't pay the actual owner of the vehicles. They paid
Arizona Road Trip.
They did.
Right.
Which did not own the vehicles. They had no right to sell them.
Right, so we have two parties who have paid something, and we need to figure out who bears the burden. And I think the UCC generally enacts a structure where we put the burden on who has the lowest cost of avoiding the burden in the first place. And to me, it seems like the UCC points in the direction of your client and not the consumers who, if we rule in your favor, are then going to have to go down to the DMV and physically look through titles.
Well, it's not a requirement. I mean, you're not required to do that, but if you don't do it, you're taking a risk. And as far as the UCC applying, it does not apply because the state of Arizona's legislature said that there's an exclusive method for determining what knowledge buyers have. It's not the UCC actual knowledge standard. You're excluded from even considering that in this case, in my view, because the legislature said there's one place you can look to for that information, and it's the contents of the title.
The legislature also passed the UCC, which says actual knowledge.
Correct. And when so you have two statutes have different standards, so you ask several questions. One, is one exclusive? Yes. This one is exclusive. The constructive notice statute is exclusive. Second, is one of them more specific than the other to the case? The UCC definition of knowledge applies to all kinds of merchandise, everything, whereas the constructive notice statute applies to subsequent purchasers of vehicles. It's very specific, right on point with the facts of this case.
Liens and encumbrances is
Correct.
what it says.
Correct, and I've given you my argument about that.
And how are we supposed to interpret with the most specific of the statutes? You're saying one statute modifies or every statute on the books, while the other one is UCC related to a purchase here of used automobiles. Which of those do we say is controlling? The one that purportedly applies from border to border, or the one that specifically applies in the context of this, under canons of statutory construction?
Yeah, there's a very clear answer to that question, Your Honor, and the answer is that you apply the more specific statute. And, I cited, let's see. So I cited, this is a case I'd refer you to. It's a recent, well, I don't know if it's recent. It's a Court of Appeals decision, Midland Risk Management Company versus Watford. And we cited at page 30 of our brief. And in that case, the Court of Appeals had to decide whether to apply a general insurance code statute or whether instead to apply an insurance provision from the transportation code that applied to vehicles.
Right, you're asking for a general knowledge statute, so that case doesn't help you. You're saying this general statute that applies regardless of all else, it requires constructive knowledge is sufficient, applies when we have a UCC that deals with sale of goods and all of that. That's what I'm saying is the specific statute, not the one that's in the other code, the other book.
Well, so you're saying that the UCC provision is more specific than the constructive notice statute?
Well, tell me why it isn't. One has to do with the sale of goods.
One of them has to do with the sale of all kinds of goods. One of them has to do with the sale of used cars to subsequent purchasers. It's much more specific. And if I can quote to you from this decision from the...
I thought it was liens and encumbrances.
Okay, well, that's a different issue.
But that's the statute you're putting your hat on.
Correct.
Right, so why is that a different issue? What is the more specific statute? The one that says constructive knowledge is sufficient when you're dealing with liens and encumbrances, or the UCC, which deals with the sale of goods, here, used cars?
Well, I would argue that the constructive notice statute is clearly more specific to the context of the purchase of used cars and what buyers of used cars know. It's right on point for that. And to me, it's clearly more specific than a general statute. So actual knowledge applies to every other kind of transaction.
Right, I mean, before you get to the general specific issue, there needs to be a conflict between the two statutes, right? Like,
Correct.
That's a doctrine we use to work out
Yeah.
when two statutes are in tension with each other.
And I don't think you need to find that there's a conflict. I think you just need to rule the entrustment statute doesn't apply at all. So there's no conflict between the two because one applies and the other doesn't. And the reason the entrustment statute doesn't apply is because these purchasers were not purchasers in the ordinary course of business because they had constructive knowledge. They were purchasing a vehicle from someone who didn't own it. And so they're not buyers in the ordinary course of business. They didn't have the immediate right to possess the vehicles, and they don't have a conversion claim.
So I'm sorry, so they were purchasing, what liens were they purchasing?
What liens were they purchasing?
Right.
Well, there were liens listed on at least two of the titles. They were the Texas titles, as Ms. Fabian noted, but there were liens listed on two of the titles.
And so they were purchasers of the liens.
Well, in those cases, that might have been the case. In the other case, they were purchasing vehicles. They were purchasing vehicles that the seller didn't own and had no right to sell.
But they were not purchasing liens in the other cases.
I haven't thought of that specifically to whether it could be proposed as saying they were purchasing liens. They were purchasing vehicles that had liens on them, I guess is how I would say it.
But the statute refers to purchasing liens or encumbrances.
Well, I don't think the statute refers to purchasing liens. It talks about knowledge about liens or encumbrances.
It says the filing and issuance of a new certificate of title as provided in this article is constructive notice to creditors of the owner or to subsequent purchasers of all liens and encumbrances against the vehicle described in the certificate of title. So that's sort of what we've been going around here. And so what I'm trying to determine is how we can get to the fact that they were purchasers of liens and encumbrances. That's the part I wanted to get to.
Or creditors of the owner. I mean, your argument is not that your client was a creditor of the plaintiffs, right?
Not a creditor of the plaintiff, but a creditor of the dealership.
You're purchasing liens and encumbrances. My view, that's like Chase Bank buying a portfolio of auto loans from Wells Fargo.
I think this is a misunderstanding of the statute, so I want to make my position clear. The statute that we just read doesn't say anything about purchasing liens or encumbrances. It talks about what subsequent purchasers know. It doesn't have anything to do with...
But not purchasers, period. Certain types of purchasers. This statute is talking only of purchasers of liens and well, I'm reading it here. I read it to you. To creditors of the owner, which we all agree these purchasers were not, these plaintiffs, or to subsequent purchasers of all liens and encumbrances. You're asking us to essentially disregard that additional language.
It's knowledge to the purchasers of those liens. They're not purchasing the lien. I think the statute is pretty clear. It's talking about the knowledge that people have, and it's saying knowledge that subsequent purchasers have knowledge of liens and encumbrances. It doesn't say they're purchasing liens and encumbrances.
Thank you, counsel.
Thank you.
Your time has expired. Rebuttal. You have 3 minutes and 56 seconds.
Thank you. The constructive notice provision and the entrustment provision don't conflict. They do two different things. The entrustment provision is found in Article 2 of the Uniform Commercial Code and covers the sale of goods. The constructive notice provision governs the perfection of security interests. There's repeated cases talking about this is how you perfect your security interest. Now, Article 9 of the Uniform Commercial Code has provisions regarding the perfection of security interest, and Article 9 also says if there's these state codes, that trumps our provisions regarding perfection. But it doesn't trump the Article 2 regarding sales. They just do different things. I don't have anything else to say. If you have any questions, I'm happy to answer them.
Thank you, counsel. Thank you both for your helpful arguments today. We will take under advisement, have a decision issued in due course, and with that, we are adjourned.